Davidson, and I am with Agape Home Care Services. We offer non-medical home care services to people who are seniors, people have disabilities who need a little bit of assistance at home. Non-medical home care service, please give us a call if you or your loved ones need any assistance with daily living activities. Thank you.
Right. All right. What we got going on?
You know I want to talk.
Look, you gonna have to
Do you
put this.
have me live?
You live. You know we live all the time. Okay. Now tell us what's going on. Put it right in front of you.
I'm just here representing Crime Stoppers.
Okay. And what does that mean? What does that entail? How does that help the community?
It helps the community see some, say something.
Okay. See something, say something. All right. Crime Stop. All right. So what we doing here? What we got going on?
Here to assist with the ladies that need help with the water crisis presentations. We have no capacity other than that. We're here to assist in whatever way.
So just here to assist anybody that has any issues dealing with the water crisis.
Yes, if they need our help, we're here.
Okay.
Yes.
Oh. She spoke with both of them? All right. Amen.
Well, we were at the district.
Right. Who are we? What are we doing here?
Lou Moquin, I'm from My Children. We're here talking about our car seat program.
Okay, you got a flyer?
Well, we've got these right here. There's a
Just hold this in front of you. So
yeah, we got a special event on May 18th. State Farm is sponsoring this along with Safe Kids Worldwide and CS My Children's Hospital. And we give away free car seats to families that qualify through.
free car seats. Okay. Stuff like that. Okay. Thank you much.
You're welcome.
So who are you? What are you doing?
My name is Fli Seamster. I'm a professor at Iowa, and I am here. Do you want me to start over?
No, go ahead. Just want to hear you.
My name is Fli Seamster. I'm here from Iowa, working with the Flint Water Crisis Public Archive. So it's a project with Stop Democracy Defense League and with University of Michigan Flint. We are building an archive of public documents relating to the Flint water crisis, and then we are also here today because we're recruiting people to conduct oral histories with us. So we are interested in talking to anybody about their experience with the water crisis. We are talking to young people and older folks alike, and we really want to have people's voices heard as part of this archive.
Okay. Thank you. Appreciate it. So who are you guys? What are you guys doing?
Oh, we're with Michigan Public, which is the NPR station in this area, and we're talking to people about the kind of news and issues they want to see covered from their community here in Flint.
Hold this up.
Okay. So this is a question we're asking people.
What would you like people outside of Flint to know or remember about the water crisis? And that's what you're posing to the Flint community.
That's what we're posing, and we have another question, which is just like, what are some issues or concerns that you have that you would like to see us report on? Because I think sometimes the news is more focused on what we think the story is, and here we want to just gauge from people who are coming through to understand what they think is important to cover, that they want us to look into, to investigate, or to just present out to others outside of Flint.
And yourself?
I'm doing the same thing. I'm helping being out today. I'm the data reporter of Michigan Public. We just want to make sure that people feel represented in the news that we produce for them, and that it matters to them, that it helps them live their lives day to day in a way that actually supports their needs.
Okay, thank you. Appreciate it. All right, so what we doing? What we doing?
Hi,
Hey. And tell us what's going on.
I always have some information here for folks.
Well, who are you with?
I'm with Planned Parenthood.
You're with Planned Parenthood. And you're talking about what?
I have all types of information. So information for the kids about like birth control, about different sexual health information that have like STI information, HIV, things like that.
All right, thank you. All right, what's going on? How we doing?
We're good. We're legal services of Eastern Michigan.
These are the different services that we provide. I'm one of the attorneys who works in the landlord tenant division. So that's me. But we also do lots of other things too. Probate stuff, lots of expungement stuff lately. It's tough for me to read upside down a little bit, but you can see what we got going on here.
Okay.
But yeah, I'm Nikki Bizarre from Legal Services. And this is Desiree.
All right.
And this is our booth.
A legal service. All right, how's that baby coming?
She's good, man. She's great.
Okay, good to go. Okay, what we got going on in here? Who we talking to?
Friend of the court, Genesee County friend of the court.
Gotcha. There's about 20,000 people that might be looking at you.
Need
So
to
what
come
do you
on
do?
down. I work the front counter and answer the phones. With any questions that you got, we try to direct you into the right place.
Okay, so what would you like people to know that they generally probably wouldn't know about friends?
If they have any questions, they actually need to give us a call, because a lot of times what you hear other people say isn't usually what happens. Each case is different.
Okay.
And we can't tell you what to do, but we can give you your options up front so that you know exactly where you stand with your case.
Gotcha.
So please make sure that if you have any questions, give us a call. Or we have a book here. We do mail things out to you. And we have a lot of outreach programs, just in case a lot of people don't feel comfortable coming in front of the court. It has changed. Give us a try.
What are you gonna add?
You did a great job. Come on down, ask us questions. We're here for both parties. We'll help you out any way we can.
All right, thank you.
Thank you.
Thank you.
All right. So what we doing here? Who we talking to?
Hi, I'm with the League of Women Voters. My name is Lorene Randall, and I'm volunteering to give information on voter education and registration today. The League of Women Voters has information
So
that
the League of Women Voters.
Yes.
Okay,
can help you with information that you might need, and starting in October,
hold it up. Hold it up.
it will be available in the library to get a copy of the candidates, what they stand for, and information about the League of Women Voters. And we encourage people to think about becoming a part of that organization as well. So the League of Women Voters have been around for a long time, and voter registration and voter education is most important, especially for our young people today, to know what it is to do for them and what they can do for us. That's our future.
All right. What you want to add?
What I would like to add is that we also have information on Prop 2, which was passed in November. It informs our voters about early voting, how you can vote in person, and how we now have 9 days of early voting. Also, that you can vote at home, and when you receive your ballot to vote at home, make sure you read it and sign it. We also have information about people returning to citizenship. In other words, those that have been in prison, we have been told in the past that you can't vote because you're a felon. Well, that's not true in the state of Michigan. We have information so that we would like our people not only to register to vote, but to become informed voters. We want them to become educated voters. And we want everybody to understand the importance of voting.
Thank you. What would you like to add?
Not to think, because I don't know what you're talking about.
Talk about the League of Women Voters and what you guys are doing here.
Get out and vote. Get out and vote. That your voice can be heard. Just get out and vote.
Thank you. Okay, who we talking to right now?
Regina Renee Miegbe.
Here.
Regina Renee.
Okay, what we doing?
I'm the library director for services and operations. We're giving away free books to the kids,
Free books.
and the adults are taking surveys to tell us what they'd like to see in the library.
Okay, sir. Okay, good to go. Thank you. I'm gonna interrupt y'all real quick. Who we talking to?
I am Talia Abdullah. I'm the executive director here at the library,
Okay,
Florida Coast Library, and I'm walking around, I'm experiencing, I'm just really thanking people for taking the time out of their Saturday to come.
All right. Thank you much. Who we got here?
Michelle Merritt, hello. Hi, everybody.
Michelle. And what are you doing here, Michelle?
Um,
Major Mary.
we've been doing the 10-year commemorative planning for the resource fair. So we're here just make sure everything goes well. In our we have the legal team giving an update on the second floor. They're going to be every half hour.
Right.
So
And I'm about to go up there in a moment and do it. Okay. All right. Thank you. All right. What we doing? Who we talking to? What we doing? Bam, like that. Like that. Okay, like that. Right there.
We're here supporting this event and supporting our kids. We got Flint kids and we love them. And so we're here offering free books and information about working at Flint Community Schools because we need the support.
All right.
We're just here.
What you want to add?
Come to our table.
All right. What you want to finish with?
I want to finish with, we have a new mobile app.
Okay.
And they can go on the Apple platform or the Android platform and download the Flint Community Schools app and find out what's happening with Flint Community Schools anytime, any day.
All right. Thank you. Ms. Nolan, I'm going to interrupt you real quick. What you doing over here? What we got going on?
Okay, so she's a certified health coach. I'm here coaching people about their health. I have some natural products, detox shoes. I have minerals. I have cards to tell you about your blood type. I'm blood type A. This little card tells me all that I should eat and stay away from.
Okay. All right. Thank you much. Okay. Tell us what's going on. What you doing?
We are doing a public archive of the Flint Water Crisis. We are working alongside DDL, U of M Flint, and University of Iowa. We want people to come and tell their stories so that we can add it to a historical record of the water crisis and make sure that our story and our collective memory is kept somewhere where it can be protected.
All right.
Yeah.
Appreciate it. Thank you. All right. Now I'm going upstairs to the legal part of it. Oh, wait. Oh, what's going on?
Oh, we have all type of vendors here today. And we also have explanations for the water settlement going on upstairs on the second floor in the Gloria Coles Library. And it's going to last from 2 to 4 for the explanations. At 2 o'clock, they're going to tell the same exact thing at 3 and the same exact thing at 4 o'clock. So if you are a member of the Napoli Skolnick lawyers, then you can come, they can pull your records right up, give you your latest status, and they can give you the latest on the settlement itself. And then they're going to have an open mic where you can ask questions. But down here, we have every part of the city from the Genesee County judicial system. We have the Nation of Islam with agricultural things. We have people from just all over the city. It's a lot of information here, and I'm on the move as usual. So.
All right.
Thank you.
Here we go. Okay.
Those are our
So
papers.
what you doing? What we doing here?
This is the Ministry of Agriculture for Muhammad Farms.
Okay.
And this is all from our farm down in
It's all
Georgia.
from your farm.
Yeah.
Your Georgia farm. Muhammad.
Yes.
Muhammad.
And Dr. Ridgely was on our show, Sister Audrey's show, that comes on the 810 Media News Group. And we had Dr. Ridgely on there, and he really represented well. But these foods are not chemicalized. They're
non-GMO, huh?
That's right.
Okay.
Non-GMO seeds. And we also have some seeds on the table.
Okay.
All these products come from the farm, the brown rice. We have recipes here for your farina bread and the navy bean soup.
Okay.
Now, one thing people don't know about the farina bread is that it's a substitute for cornbread because corn wears out the stomach. It wears out the lining. We can't live without our stomachs. So everything we have is great. It tastes just like it. Take that recipe. The cornbread is killing us. It's killing us. You can make your own bread. We gotta go back to what grandma used to do. Make that bread, make your cakes with the pastry flour. You know, it's all here. We're covering everything, new products coming out all the time. We have a cleaning product. I don't know where that little sign went. But this is a new product from Muhammad's Farm. A lot of our people are making products. Yes, they're making products. This is an all-purpose cleaner. And when I say all-purpose cleaner, you can use it for your laundry, cleaning the house, deep cleaning. You know, it's good for everything.
All right. Appreciate it.
Yes,
Appreciate it.
sir. Thank you.
There we go.
And they can contact me if they want to order and they're having trouble with it. I
Okay.
can help them.
Good to go.
Yes, sir. Thank you. Spots are taken away. So you want a belly bag or separate?
All right, we're going up, going up. Fire. What's going on? Why are you looking so serious? We live. Say something to somebody. Oh, we live. Say something.
What's up?
All right.
I don't know yet, but
This elevator is taking a long time, so I guess I gotta go. Mhm. All right, all right. All right, all right. How y'all doing? That elevator take 10 years. Got it? All right.
They would qualify for compensation off of that alone, whether it was blood or bone. And because that was a question asked, I wanted to answer that particular question. Their kids were like 0.9 parts per billion or higher could qualify them for compensation, much less than adults. And then other ailments with them, neural ailments that testing such as on Robert T. Longway, the Neural Development Center, or the CANTAB testing that groups like ours did. So we're not a representative today of the courts. We're not a representative of anybody other than ourselves. Our primary goal in participating in this commemoration today, because some of our clients, as Claire said, would be here, and we wanted to be available to look our clients up and tell them what's the status of their claim. And we have staff here to do that. If you're not a Napoli Skolnick client, then we're going to give you the Archer Group's number, who can tell you who your lawyer is, or if you have no lawyer, then you're supposed to deal with them directly. And so that's the limit of what we are going to do here today. Now, what I've agreed to do with Claire, and I, as a contractor of Napoli, spoke with them about this, is I am going to discuss or regurgitate some of the findings of the April 16th, 2024 report that Deborah Greenspan filed with the U.S. District Court. I have a copy of her 18-page report here, and I'm going to talk about some of that. And for those of you all who are media or podcast sources, we're going to put a copy of that report on the table for y'all to hopefully share in consumption. You take pictures of it, do whatever you need to do, and eventually I'm sure one of y'all will take it, because this is the most recent information that I'm aware of that's talking about the status of the case. I've been blessed to have the opportunity to meet Deborah Greenspan, and I personally sit in on 75 hearings with her and our clients. I brought our clients to the hearings, which were in my office, and she came in, and basically what she did is swore them under oath to try and accelerate the acceptance of their claims. And this is something, my understanding, that she's going to do with other firms to try and accelerate the processing of these claims. And so let's go into that. And I'm gonna take Art's question, because you know he's one of the #1 advocates here. But other than that, I'm gonna take the rest of the questions afterwards. Go ahead, Art.
No, I just wanted to ask you how you was right there with Deborah Greenspan. I know that the appeal for her is what, $175 after reconsideration. If you're denied and ask for reconsideration, you have to pay, I think it's $175 in order to have the appeal. What if you don't have an attorney, where you said that she was doing that? How do they know, or the people know, that they have to pay the $175 to get to Mr. Greenspan if they deny?
Well, first of all, I don't think I said that the meetings I was sitting in were appeals for $175. They weren't.
Okay.
That would be a mischaracterization. They were just hearings for that she decided to have with individual clients to try and accelerate the review. She have a team doing a review, but she's now participating in that process herself. But there is some information in this document about the appeals. I'm not aware of $175. I know that there's been thousands of appeals filed, and some actually heard for reconsideration. And I'll speak to that in her. She's speaking on that in this brief. And I think you should get a copy of that too.
Yeah, I got
So let me again restate. I do not represent the court. I do not represent Deborah Greenspan. I'm just one of Napoli's low man on the totem pole. Normally, let me just say specifically what I do. I'm one of the persons that interact mostly with the clients. Me and my team gather documents, collect them, and turn them in for processing. That's the meat and potatoes of what I've been doing since 2018 for Napoli Skolnick at the Flint level. And it's been wonderful. I've met thousands and thousands of families and people. Yesterday, you might have saw on WNEM and Channel 5 us over at just around the street here on 1018 Decker Street at Amanda Wheat. She's one of our clients. I mean, this young lady been suffering for a long time. She's lost her residence. She has 4 kids that have behavioral issues. And we teamed up with Clean Water Collective, and we went over to her house yesterday to test her water. Many of you that are advocates 100% know that Flint is still experiencing problems beyond this water crisis. Many of you all know that. And many of you who are knee deep in this know that there's a problem with the distribution process of water in the city of Flint. That system was designed for 200,000 people, and we have under 100,000 people. So there's going to be chlorine issues. There's going to be all kind of issues, in my opinion, that's going to go beyond the life of this suit. And hopefully, you know, we're never going to get as Flint residents what we need to get at the benevolence of anybody, such as a law firm. It's going to be by the efforts of us coming together and trying to fight for these things ourselves. Having said that, what I want to do now is go into some of the details about the April 16th, 2024 report from Special Master Deborah Greenspan. Now, she noticed up this report in February of 2024, and she called it Notice of the Special Master regarding the status of the claims process under the amended settlement. So she's talking about the status of the claims process under the amended settlement. And a little bit of the background was the amended settlement agreement was approved by a federal district court and all federal court orders necessary around March the 3rd, 2022. So an original settlement was made in August of 2020, August. But then there was a lot of things that was amended and changed, and that agreement was entered in March. Approximately 30 individuals had filed 3 separate appeals to the amended settlement. And those were resolved around March of 2023. And the state court administrative office appointed a probate judge to address probate-related tasks required by the settlement agreement, including review and final claims of minors, and to determine appropriate distribution of funds for the benefit of certain minors. And so, people have died since this suit have started. People have died. And there's a probate process. Normally, let me say this, normally if a person dies in Genesee County, you got to go down to probate court and somebody has to become personal representative. That's a $300 and something process. I'm happy that our firm trained us on how to fill those documents out in pro per. So Flint people didn't have to go and pay lawyers to do this, because they were having to go to the probate pros and different lawyers who was charging them $1,500 to $3,000 to do their probate. Now, they're going to use their probate for more than just a lawsuit. If a person dies and they had some property left or vehicles, somebody have to dispose of that. So that's why probate should occur outside of the lawsuit. But what we've done from our office is about 175 people's paperwork for them to go and do the probate, absent of having to pay a lawyer for that. We did it in pro per. We sent them down and we didn't represent them, but we filled out that we've successfully gotten back over 175 letters of authority for personal representative, meaning we've done about 400. Some people just didn't go file it. They would pay their fees, or many of them qualify for waivers for their fees. But the court, according to this document from Deborah Greenspan, the state court administrator have appointed a probate judge to address probate-related tasks associated with this lawsuit. Some people, depending on the amount of money they get, the court have came up with a form, a one-page form that they can notarize for a small estate, and this probate judge is going to go ahead and dispose of that without them having to pay money. So they're trying to find alternative ways for Flint people to not have to continue to spend money in order to prosecute these cases, especially if a person deceased you're trying to pick up the claim for a deceased relative or a deceased child or a deceased parent. Overview of settlement terms and claims review process under the amended settlement agreement. Again, the settlement provides 30 different compensation categories covering a wide range of claims of injury and damage, including claims for minors and adults and claims for personal injuries, property damage, and business loss. So out of these 30 categories, you have personal injury categories based on age, and you also have property damage categories, and you also have a couple business loss categories. And you can always refer to the Flint Water cases qualified immunity fund categories, monetary awards, and required proof grid, which is write this down, ECF number 1319-2. So what that does is those are court numbers that when you go onto the court website, it'll help you find this information. I'm not representing the court, but I'm just trying to regurgitate information. So that schedule of those 30 categories was filed as ECF number 1319-2. It has the 30 categories of compensation that will be involved in this suit.
Repeat that again.
All right. ECF number 1319-2. And by the way, Jamie Davis, one of the office assistants for legal research / Natalie Skolnick, has been working with us since 2018 on this case. I want to acknowledge her, and Valencia Jordan, one of our specialists who go out in the field primarily to go help y'all gather the documents, because you all don't have transportation or the wherewithal to come into the office. She go get it, and she bring forms to y'all to get signed. So I wanted to bring people that was doing boots on the ground work to make sure everything was all right.
Can I have one question before you go on?
I'm gonna take all questions at the end. I want to just go through this report and I'm gonna take questions at the end. The compensation schedule includes 21 different categories for children and 9 categories for adults. Out of those 30 categories, 21 different categories for children and 9 categories for adults. The compensation schedule provides for different compensation amounts based on different factors, including your age of the claimant at the first exposure to Flint water, whether the claimant has evidence of lead in their blood or bones, whether the claimant documents certain medical conditions, including cognitive conditions, and whether the claimant has a residential property or business that receive Flint water. Now I'm reading almost word for word from this report. Also, the claims review team of the court, according to Deborah Greenspan, is charged with the responsibility for determining whether a claimant has documented exposure to Flint water during the relevant time period. What's the relevant time period? The relevant time period is April 25th, 2014 through July 31st, 2016. April 25th, 2014 through July 31st, 2016. This is the period of time that this lawsuit is based off of. Not before, not after. However, there is categories of compensation called exposed after the period. So after July 31st, 2016, there was still a path for children and children that was born after July 31st of 2016 to be on the lawsuit. So those are there's categories for that. But the qualifying period is April 25th, 2014 through July 31st, 2016. All right. Now, whether a claimant has documented any qualified injury, whether a claimant can show ownership or lease, for example, obligation for water bills, for any eligible Flint property, and whether the claimant can show a business loss as defined by the settlement. Each claim is reviewed according to Deborah Greenspan under a 3-step process. First, the claim goes through initial review. And at this stage, the review team can determine the basic characteristics of the claim and can make an initial determinations of whether the claim is a minor, the claimant is a minor or an adult, whether the claimant has documented exposure to Flint water, and whether the claimant has submitted information to support a claim in a specific compensation category. The reviewer would then assign a determination to the claim and identify any deficiencies in the claim. Let me stop there for a second. So we turned in clients' paperwork years ago to the court, complete or incomplete. We was given a deadline as a law firm to turn it in. We turned the paperwork in, complete or incomplete. Now, if we turned in incomplete paperwork, we still, until they tell us a check is coming for clients and that part is closed, we're still fighting to get that information. We got clients that have moved 5 to 6, 7 times. We had clients we done sent investigators out to, we done sent Valencia out to. Jamie done called 50 million times. We've emailed. That's our job. That's what we're going to do until the lawsuit is over. It's not a question of fault. It's just what we have to do. But once the court review, they're individually going to everybody's case. And when they review it in that initial determination that I just read, Deborah Greenspan said her team do, they try and identify deficiencies. For example, let me give you an example of a deficiency. We had they say that the settlement claim forms that everybody had to fill out, the address on the settlement claim form might not be that same address on the lease agreement that a client turned in to us to say that's where they were living during the time of the exposure period. So that has to be reconciled. The court is like, where did they live? We trying to reconcile this. Now they've told us they live in these two different places. So we turned it in, and we're some people just like don't remember or whatever, but we got to figure this out. Another example of deficiency is I say that I was living with you. You lived in Flint. The water bill was in your name. The utility bills were in your name. Everything was in your name. But I'm saying I was living with you. And I gave your address as a place that I was living. And you put on a piece of paper, Reggie was living with me in 2014 and 15. And that was turned into the law firm. We subsequently used that as proof that you was living there because you wouldn't give us nothing else. Even your ID at the time we could use, but you said you don't have your ID at the time. You signed up in 20, but in this, we try to backtrack for 14, 15, and 16. So the court identified that as a deficiency. They say that's not enough information. So what happens is the court got their own team. That they done looked you up, CoreLogic, LexisNexis, Skip Trace, and they paperwork say you was living in Mount Morris in 14, 15, and 16, or that I was living in Mount Morris. I wasn't living with you. So they like, well, let's resolve that. So we have affidavits now that you would sign under the penalty of perjury saying that I was living with you during that period of time. Now, some people signed them, some people haven't. So what happens is that could be a deficiency. Now watch this. Even if you was living in Mount Morris during that time, but you was working in Flint, then we can use your W-2 and show that you were exposed in Flint. The lawsuit requires that you were living consistently in Flint for 21 days in a row out of 30 days in between April of 2014 through July of 2016 as a baseline. That you had to be in Flint for 21 days out of 30, sometime in between April 25th, 2014, which is the first day we went on City of Flint Water, to July 31st, 2016, which is a questionable deadline on the being over. We got Flint Water in around October of 2015, and there had to be a series of tests saying everything was clear. And that last date of determination was July 31st, 2016, real or imagined. So the deficiency process is identifying things like that. And the good news is a lot of us were able to overcome deficiencies. And one of the things that had happened that I was sharing with Mr. Woodson is that the special master started meeting with clients. And one of the reasons she started meeting with clients is because if I said I live with Miss X, I'm gonna call you Miss X. Okay. If I said I was living with Miss X, but I had no proof that I was living with Miss X, then I came to a hearing and the special master swore me under oath and said, now Reggie, what was you living during that time? I said, I was living with Miss X. Well, our records show that you was living out in Mount Morris on 1313 Mockingbird Lane. Well, you know, I did live there, but I left and I was for a period of time living with Miss X. What period of time? I tell her the period of time. What's Miss X's name? I tell her what's Miss X's name. Her and her lawyers are sitting there. They have who was living in that property at the time, who name the water was in at that time. They have facts that they can use to corroborate if whether or not they believe what I'm saying. So they end up believing what I'm saying and they approve my claim. I qualify under the personal injury category. I just couldn't confirmed that I was in Flint at the time. So through this hearing did what my paperwork wouldn't do. My paperwork was shaky. So the hearing approved me. And the special master, for example, I don't know how many other firms she's doing this. She met with over 75 of our clients doing this process. It didn't have nothing to do with appeals or anything. She was just trying to do the first stage of approval of a claim. And she had missing information, and she was able to take people under oath, use the information she had to determine if we was telling the truth or not. Now, will she do that with every single person? I have no idea. But I know that that's something that Special Master Deborah Greenspan have done to try and accelerate this claim. And so I'm going back to her report. Each claim is reviewed under this process. The first step is the initial review. The second step is to try and determine the deficiencies, and then let the client's lawyers or individuals know what those deficiencies are. We get people coming in our office every single day, meeting with our team, and we can click onto their file like we're going to do with some of our clients sitting here in the audience who we might have been contacting and they never got back with us. We're going to be able to pull them up, and we're going to be able to ask them if whether or not we're going to show them what deficiencies they have and try an effort to try and overcome those deficiencies. So these are the common issues that's happening in the analysis process. And as she said, where the procedures have been important. They promote accuracy and consistency in evaluating claims under this complex terms of the settlement. They identify common issues and situations where the claims analysis process could be improved, and they prevent fraud. Well, whether y'all believe it or not, there's been people who done claimed abandoned houses and didn't even live in Flint and signed up for the claim because kids could potentially qualify no matter what. Do we kind of know the water, young lady, back to that? If anybody got the extra water, you okay? It's some free water downstairs, man. Okay, I'm just concerned because I know you've been going through throughout this process. So there's a fraud part of this too, I think. Now, listen to this. Claim statistics as of February 28, 2024. The settlement administrator received approximately 46,000 claim packages. Some claimants submitted more than one claim package. And that means that within the 46,000 number, there are duplicates, and the number of actual claimants is much less than the 46,000. The claims administrator have identified 16,600 claim packages submitted for minors, meaning individuals who were children at the time of the water crisis. And of those minors, approximately 10,600 are still minors today. And that was as of February 28, 2024. The claims administrator have identified approximately 28,700 claim packages submitted by individuals who were adults at the time of the water crisis. And keep in mind, out of those 28,700, though there are duplicates within there. So we know that's not the actual number. It's something less than that. So you all keep this fact in mind, because this is a fact unchanged by time. At the time of the settlement, we had less than 1/3 of the population of Flint signed up for the water crisis case. Less than 1/3. What did that mean? Part of what that meant was, I believe, as many of you believe, that this claim should have been much bigger than what it was, especially if we do that in comparison to the Larry Nesser case. It should have been much, much bigger. But unlike the Larry Nesser case, that case had over 97% participation of the victims. We didn't even have 33 1/3. And I don't use that as no excuse because there is no excuse. But imagine if we'd have had at least 2/3 of the people of Flint participating. In my humble opinion, I believe this will be over $1 billion lawsuit. So participation was important. But no law firm can automatically sign up a Flint resident absent of them signing a retainer. You can't do that. That's illegal. I just wanted to mention that because I know that's been a great source of frustration for me as well. Um, in addition, these claim packages can include more than one actual claim. So as an adult, you can have a personal injury claim, and you can have a property claim, and you can even have a business claim. We have clients that are landlords that live in Flint, so they made a personal injury claim. Also, they made a property claim for the house they lived out of, category 28, and they made a business claim as a landlord or a business owner. So one individual theoretically can have three different claims. So based on the 28,000 adults, which we know there's many duplicate files, and the 16,600 children, the individuals who submitted claim packages have asserted over 90,000 claims in this water crisis lawsuit, according to the report of the special master. I want to reiterate along the way that this is not my report. This is not Napoli's report. This is the report published by Special Master Deborah Greenspan. And so the adult claimants have submitted over 50,000 claims for injury, and with a footnote. The footnote is the number of injury claims include multiple injury categories claimed by individual. So an individual might be in multiple injury categories. For example, a person could have Legionnaires, and a person could have lead exposure, as part of their serious personal injuries. And over 13,000 claims for residential property damage. There are approximately 1,100 claims for business property damage and 800 claims for business economic loss. Approximately 21,000 claims have been submitted on behalf of minors at the time of the water crisis in the 16,600 claim packages referenced above. Many claimants did not allege any particular compensation category on their claim forms. So what she's talking about is those claim forms that y'all had to go into y'all lawyer and fill out them 5 claim forms, one of which said that once I get my money, I won't sue these same people for the same thing. One of them said, here's where I was staying at the time, from 2014 all the way up to the date that you did the claim form, and it asked for your clarifying information. You might have also filled these claims out for your children, and you would have put yourself as the fiduciary. You know, a lot of grandmothers did that, filled out the paperwork for their grandkids. And now that we come close to settlement, mom and them came out the woodworks and said, hey, I love grandmama like a play cousin, but I'm taking this case back over, and it's been create a source of great confusion. And we trying to deal with that as well. And one of the ways we deal with that, if you a grandmother and you signed your grandkids up and your child have not asserted that they have a problem with that, then we're asking you, we might have the kids' birth certificate that show the kid and their mother's name. We need the birth certificate of the mother that shows the mother and show you as the parent. Now we're able to establish the grandparent-grandchild relationship off of those 2 birth certificates. That's one of the things that we were doing to keep grandmama on the claim without us having to do some complex guardianship stuff. So all of these type of dynamics, y'all, are taking place here. In between our report, I just want to share that with you all. History of the claims process. The claim submission process began January of 2022. The final deadline for the submission of claims was June of 2022. Y'all remember that deadline when they told all those law firms, we got to have everything in by June of 2022, which they really switched to July of 2022. Now, the claims administrator had reported that the process of incorporating a voluminous data and millions of pages of documents that were submitted along with the claim forms was labor intensive. Now, in January of 2023, Deborah Greenspan said that she submitted a report and recommendation to the court seeking approval to add more resources to the claims process and address these issues of important data from one system to another and enhancing the review process. And there was a report and recommendation of the special master for additional claims administrator services for the partial settlement. And that's ECF. Now, if you go onto the website, ECF number 2341, and that was in January 31st of 2023. Now, the court approved additional resources under order under ECF number 2344 during January and February of 2023. And so then the claims administrator team recompiled the data according to Deborah Greenspan, tested the data transfer process, set up a claims review program, and imported that data over so that it can be correctly matched with the claims. And in March of 2023, the claims review process restarted. In March of 2023, they restarted the claims process that they started in 2022 and stopped. And then they restarted it again in 2023. And many of us didn't even know this until we saw this doggone report. And the first notices to claimants were distributed that next month in April of 2023. Some of you have received from your lawyers and or from Archer a letter, a notice saying that the claims administrator have reviewed your process and agree that the category you picked on your claim form is the category we agree that you should be in. No further information is due at this time, and we'll get back with you. They approved your category. So if you got that letter, the next thing you waiting on is just a what we call it, an awards letter that's gonna say how much you're gonna get. All right. So in March of 2023, she submitted a report that projected that the claims review would likely be completed sometime in 2023. We know that didn't happen. That projection was based on the initial statistics from that first report. Now, what they do since then, I'm going to another part of a report saying obtaining additional data from third-party sources to assist claimants in the completion of their claims. That enhancement process that she got money and approved for. So during the course of the implementation of the settlement and claims review process, Deborah Greenspan, in conjunction with co-lead counsel, co-lead class counsel, and co-liaison counsel, and settling defendants, determined that it would be helpful to claimants to obtain additional data from a variety of third-party sources. So the court and the attorneys got together and basically started getting notices out. Many of y'all got that notices saying, if you had children, we finna pull school records. Many of y'all got the notices, we finna pull. So they just started pulling school records because parents wasn't able to get them, or parents was giving them incomplete records. So they just started pulling school records. Another thing they did, for example, we obtained a voluminous water billing records from the city of Flint. So the courts pulled all of the water bills that whoever was paying the water bills, they pulled all of the water bill accounts from April of 2014 through July of 2016. They trickled that down to the attorneys. We have a copy of that in our office. When our clients come in, if they tell us where they were living in 14, 15, and 16, we can pull that up and we can see who was paying the water bill. Because a lot of times they'll tell us they was paying the water bill, and we was like, no, Jack Marshall was paying the water bill. Who was that? That was my landlord. Okay, but I was paying him. I said, okay, but the problem gonna be the water bill is in Jack Marshall's name. So now we have to engage into a different process of you getting an affidavit from Jack Marshall saying you was paying the water bill, or providing us your lease agreement with Jack Marshall that says water bill is included in the lease. And these are the challenges that we're having and trying to complete this, because it's been a long time. And some people are like, man, I don't even know where Jack Marshall at no more. So it's been difficult to try and get where we need to get because that could be a $5,000 property claim for you just off that one document. So it is worth finding. Plus, you all, let me just stop and say this. And this is just me personal. This is my personal, this Reggie talking personally. Y'all need to know these law firms are not nonprofit organizations. Their motive is that third that they're gonna get. So it is a myth that they want this to continue to go on. They're not going to get any more money with it continuing to go on, because if I got 1,000 clients and I only have paperwork for 200 clients, then those 800 clients I have that I did paperwork for, that my team went and talked to, I can't bill the court and get paid for them. These are contingent lawsuits. I only get paid off of what I collect. If my clients don't get paid, I don't care how much work I've done for them, I don't get to bill the court for that work. I don't get to bill the court and say, pay me. These are contingent lawsuits. Now, the top 4 law firms that was doing most of the heavy lifting, there's something called a common benefit fund, which most of y'all are saying the lawyers already got paid. That common benefit fund is the top lawyers who are doing most of the heavy lifting. That's what they get to charge a percentage to the lawyers, the other lawyers who wasn't doing the motions, the interrogatories, the depositions. They have to pay a percentage of what they're going to get to those lawyers. And they argued and went in court, and they went to appeals court. And when they determined what that percentage was, that was those millions of dollars that the lead attorneys were going to get. But the actual fee that attorneys are going to get paid is going to be distributed when you get your money. So lawyers are rolling the dice. It's a numbers game. They're not necessarily going to get paid for all their clients. Now, the flip side of that is, and this is my understanding, once the court determines who's going to get what, after the deficiency process, there's going to be cases eliminated. There's going to be cases staying there. The court is not going to leave nothing on the floor but the $35 million set aside for the kids. That's my understanding at this point, because all things are subject to change. I've seen stranger things. So you all need to understand that. Now let's go back to the special master's report. We have also assisted claimants in obtaining their blood lead test. So the court subpoenaed through MDHHS, the Department of Health and Human Services, all of the blood tests that people were taking between 214 and 216, because at one point they gave a directive to your doctors and mine to lead test you. When you came in for your physical, if you came in for your quarterly doctor's report, they drew blood and they were ordered to test for lead after advocates such as Artnem made folks start doing stuff. So they started testing people lead and keeping a record of that. And so then the court subpoenaed those records so that they can see if whether or not you had that. Now we can see the report, because you and I sometimes have been unsuccessful getting these reports from your doctor. Y'all fill out a HIPAA high tech, and maybe you didn't tell us who your doctor was on the HIPAA high tech. And or you tell us and we submit it to a third party who go try and get your medical records from your doctor. And sometimes your doctor give them and sometimes your doctor don't. So in the 4th stage, Jamie really came up with the idea in our office. Hey, y'all go get your own medical records, bring them to us, because they have to give you your records. And if they charge y'all, Reggie will pay for it. And so that's what I've been doing. I've been paying for medical. Y'all bring me the bill, I pay for it. And of course, I'll fight nappily to get reimbursed. So these are some of the things they did with the enhanced process. They started subpoenaing mass amounts of data so that they can try and give them to us, so we can try and see if whether or not our clients fall into categories. For example, again, if you were an adult, the EPA say 15 parts per billion lead is normal. The lawsuits say if any adult have 5 parts per billion or higher, they get to get some money. So it's category 23 as an adult, you can get in there if you got 5 parts per billion to 9.99 parts per billion lead. And if you got 10 parts per billion lead, you going into a higher category of category 22. And so, but if you have lower than that, than 5 parts, you're not going to qualify for compensation as an adult. Now, if you're a kid, if you got 0.99 parts per billion, so if you have 1 part per billion lead in your system, you're going to get some money as a kid, because the science say kids are affected more. Kids 1 through 6 are affected in a way much worse than anybody else. That's why the majority of the money going to the kids 1 through 6. Then the next pot is kids 7 through 17, and then adults are getting about 12% of the money. Her report went on to say the test data is used both to approve compensation categories based on test results and to allow the claims administrator to confirm exposure to Flint water where the data shows the claimant's address at the time and test. So again, there's all the law firms are having problems with where you were living at the time. And I know I'm methodically taking my time. I'm gonna speed up a little bit, but y'all gotta understand, I know many of you all have not seen the report from the special master. So what we try to do, we being the Flint office in Annapolis Skolnick, is share with you this report, because this is the closest update we had of what's going on. All right, so we have also obtained birth certificates for claimants, which are used for both identification purposes and determine the appropriate legal representative of a minor claimant. Whether y'all believe it or not, there has been people that have come into this town and been signing up kids, and they ain't bit more the guardians over these kids than the man in the moon. Wow. And that's been an interesting process. I know in our office, we had a lady come and say, excuse me, y'all have my daughter signed? Because we had lost contact. So we skip traced and found the kid's real parent. And the real parent was like, let me see the retainer. I don't even think I signed this child up. So there's been some interesting anomalies happening here that we also have to wade through, because the court has a duty to not pay nobody that have not been exposed in Flint, or to let somebody pump fake and try and get money for the kids. And here's a news flash about that. That money for the children is going to be in a controlled trust. You're not just going to be handed a check. So you can, and I'm not saying any of y'all going to do that in this room or anybody in particular, so that a minority amount of people can run the Al Sarah, you understand me, and try and get a Cadillac, or Walmart. You see they stacking up on TVs and stuff, because they know we, as a poor community, stuff go in one hand and out the other. And I hope that, you know, those of you who have the wherewithal and have community organizations will come up with some literacy information. And you know, I wish that all of you all who are strong advocates, Miss Riley and people like that, I wish y'all would get together and go to the land bank and make sure they offer everybody houses like they used to do, with $500 down and show your Flint ID and let you have a land contract. You know, we need to make more homeowners and do some responsible stuff here. And we know we don't like the lawsuit. We know y'all know this ain't no savior lawsuit. Y'all know this ain't perfect. It's very imperfect. But let's do the best we can with it. And I think those of y'all who have the skill sets and the wherewithal and the cultural capital in the community, because you all been advocating for years, I hope that you all would develop some of these things so people can get the maximum out of what little change they get. And so these the records were they used in some specific records they obtained was this: 2.6 million water customer billing records, 77,000 school enrollment records, 40,000 blood lead test records, 28,000 service line records, 8,300 requests for birth certificate records, and 2,800 claims have sent to the process of verification of property ownership. So they've been pulling records from the county recorder's office. If you say you owned a home, you know, during 2014, 15, and 16, you might have bought that home in 2004, but you may not have, the county recorder don't show it being sold or lost to taxes until 2016 or 17. So you still get the, even though you don't own that home no more, you had it during the contamination period, so you get to do a property claim on it. You might have lost it to taxes, or you stopped paying the water bill and they foreclosed the lien on it and eventually took your house. You still get to make a property claim. Now, I'm gonna go to something the brother brought up. Now we're gonna talk about the current status of the claim review process according to Greenspan. After a claim has been reviewed and has completed the steps outlined above, the deficiency process they're talking about, the claim is eligible for a notice. The notice tells the claimant the outcome of the review, whether it is approved, whether the claim has deficiencies that prevent approval at that time, whether it is approved for a category that is different than the one claim. Some people was in category, they wrote category 22, but they blood lead report said they had 6 parts per billion, so they was approved for category 23. Each claimant is permitted to ask for reconsideration. This is baked into the cake. You don't have to pay no extra money for this. This part is baked into the cake. Each claimant is permitted to ask for reconsideration of the claim if the claimant disagrees with the notice and is permitted to provide new information to cure the deficiencies. So a period of time is given for people to cure their deficiencies. Or if they say you in this category and you think you should be in a higher category, you can challenge that without having, that's baked into the cake. You don't have to pay no money to challenge the initial determination by the court. The claims administrator will then review the claim again and provide a reconsideration notice to tell the claimant the outcome of the review on reconsideration. Jamie found a lady who had a blood lead test that basically said 5.1 parts per million, but then we had a bone lead test that showed her at 10 parts per million, 10 points. So that bone lead test was used in the reconsideration process, and she went from category 23 to category 22. There's been some people who said, my doctor said my high blood pressure was because of contaminated water, but the medical records they turned in didn't have no record of that. So that lady went and got the records herself, and she brought the records back with a bill. I paid the bill. So, and then we turned that in and she got reconsidered. So these things are happening as we speak. You're just not seeing it. And I need to tell y'all this. Imagine having heart surgery. You go to the doctor for heart surgery. You in the operating room. The doctor is busting open the left ventricle and the aorta lumina valve. The doctor is not going to wake you up out of anesthesia and say, by the way, I'm picking on you, Miss Riley. By the way, Miss Riley, we're getting ready to cut the left ventricle and go in here. No, it's a professional. The doctor gonna wake you up when it's over with and tell you what happened. And if the doctor needs something along the way, they're gonna do it. Lawyers are professionals too. They're not gonna call you every day. They're not gonna hold your hand. They don't even have the manpower and wherewithal to do that. Y'all be signing Superman status to folks that just don't exist. They don't have the money and the wherewithal to do it. The lawsuit would never be over. But even having said that, we have clients, and Jamie can tell you some of their name. I don't care what's happening. Every Tuesday, Jamie, what's up? They come in there and they want to know what's going on with their lawsuit. And we deal with that. Even though nothing has changed, we told them ain't nothing changed. We're going to notify them. But if you are concerned about your lawsuit, call your law firm. If they're not answering, go see them. Make sure you know what's going on with your case. Make sure you know if you have any deficiencies or not. That's part of your responsibility too. Make sure you know what the stat. Ask your lawyer, hey, what category am I in? Am I in the draft category? Have the court reviewed my case yet? Did I qualify for a property claim? Didn't I turn my lease agreement in? Where am I at with that? Am I getting money for a property claim? Am I getting money for a personal injury claim? Ask these questions. They should be able to answer them, and they don't owe you no lie. If you're not getting nothing, I'm gonna look you straight in your face and say, hey, look, according to the medical director, you ain't qualified for nothing in terms of personal injury, but you got a property claim, or vice versa. Because that's the duty owed to you by your lawyer. They not gonna come on Facebook or hold a press conference and say that type of information about their client because of attorney-client privilege, according to my understanding. But don't worry about it. Y'all got some hard-hitting advocates. I ain't gonna say their name. They're gonna be pushing buttons to make sure folks find out stuff anyway. Y'all got some hard-hitting advocates that's gonna do their job to find out what's going on anyway. Where'd you order that? And y'all got some people who will do that. And thank God for that. See, let me tell y'all something, and I'm gonna finish reading this report. I don't care what your position is or what your view is on the lawsuit. What you eat don't make me use the restroom. So I'm not mad about that. Everybody's entitled to their position. And thank God we have people that have various different positions. Thank God we have people that's out there doing the uncomfortable work of uncovering stuff and exposing. I don't take it. I know folks them threw rocks at the group I don't work for. I don't care nothing about that, because if it's true, so be it. But because we are all entitled to relief. Now, I'm going to tell y'all this. If you think this lawsuit is Jesus the Christ, it's not. There's a lot of work to do. And I'm hoping and praying that the advocacy that produced some of these cancer cluster studies that's coming and things like that will allow us to have a renewed lawsuit very similar to Camp Lejeune. You know how Camp Lejeune got another lawsuit? They went to the legislatures and they passed the law to make you open this stuff back up and pay people. We're gonna have to do that in Flint. Y'all, I'm telling y'all, ain't no need of y'all resting and getting comfortable. We're gonna have to go, in order to overcome statute of limitations, we're gonna have to go to the legislature. So let this just be the beginning. Don't let this be the end. Don't let this be the end. And that's just me talking. So as of March 28, 2024, the claims administrator has distributed 31,478 notices. So they have told 31,000 claimants whether they have deficiencies or not, whether they've been approved or not, whether they need more or not. Some of the notices have identified deficiencies, and many of those claimants have submitted reconsideration requests. And as of March the 28th, 2024, the claims administrator have received 11,359 reconsiderations, which you might consider appeals. And ain't nobody had to pay no money for them appeals. It's baked into the cake. They done received over 11,359 of them, and I know more are coming. Now, if the claimant does not agree with the reconsideration result, the claim may be submitted to appeal. And I think that's what the brother was talking about at that point. And as of May 28, 2024, the special master have received 149 appeal requests. And in addition to formal appeals, the special master also addresses claims that are escalated for review. So some claims, whether they like we have escalated some claims on a part of our client that we didn't necessarily find out, that we don't necessarily consider reconsideration. So if Jamie or Valencia go out to somebody's house and she get a document that show, oh, they did live here during this time, and this lease agreement say they was paying the water bill, even though the water bill in Joe Marshall name, who don't even live in Flint, that document Valencia was able to get. We able to scan into our system. We got a rapid scanner right there. It'll be in your file in a few minutes. And then a robot will tell our review team, and now they can get that back to the court, and we've been able to change the dynamic. So until this case is over with, things like that are happening. And I know part of the problem is y'all don't see it, is a need for communication, but I want y'all to really embrace that Miss Riley example I gave of heart surgery. We don't have the bandwidth to do that. So call us, or come by, or do whatever you got to do. Throw a rock, print, paint, stamp, stain, cut card, mark or engrave, do something. So the claims Claims that have not yet received notices are in varying stages of the process. Now, y'all, I'm reading from the special master's report that came out April the 16th, 2024. And y'all come and get this case number off the top of it when we get done, so you can go online and download this report for yourself. Valencia gonna set 1 or 2 extra copies on the table, but y'all let the podcasters and the media people copy those first. They probably gonna jack them and take them. But so y'all just write the numbers down off of it and just let it work, because they're gonna do what they need to do to help get the word out one way or another, and they need to do what they need to do with their comments and criticisms and everything they need to do, so we can keep this advocacy going. All that's necessary. All that's part of the process. Ain't nobody mad about that. At least I'm not. The claims administrator projects the initial review process will be completed through all steps in the process around the end of June 2024. Lord Jesus, let me say that one more time. Let's clarify. The claims administrator projects that the initial review process will be completed through all the steps in the process around the end of June of 2024. The entire process will not be completed at that time because the pending reconsideration request and appeals. So you got lawyers telling Judge Levy and Special Master Greenspan, when y'all get through in June, look here, different lawyers are saying different things. Can you please, whoever ready to go, let's pay them, let's drop the rest of the claims, and let's keep it moving. There is some conversation. Now, this is just me talking. This ain't nothing formal. Let me step right here, make that real clear for y'all record. There is some conversation that y'all need to set some money aside for the adults too. But the conventional wisdom say, if after 10 years as an adult, you haven't done what you're supposed to do, you're not a kid, and you don't get the benefit of forever, because some people have did their stuff as soon as they got it, and they've been waiting for years for their money, and it's time to pay them. So in this imperfect suit, you all need to know that there's a battle going on to pay whoever's ready right now, and whoever's not ready, dismiss their suit. If there's kids, there's $35 million set aside so that whatever their parents didn't do, they still have access to. That's what the set aside money gonna be for the kids due to no fault of their own. Now I'm gonna tell y'all something else before I wrap up her report. This is a sidebar. The Veolia lawsuit, which really is imperfect. Everybody is not on these other lawsuits. If your lawyers did not file for you to be on them other lawsuits, you're not on them. So you might want to check with your lawyers to see. We have thousands of clients who are not on the EPA lawsuit because the court didn't extend the statute of limitations on the EPA lawsuit. Some people signed up with us after the statute of limitations to be on the EPA lawsuit had closed. So if you was signed up with us before 2/18, what is it, March of 2021 or 19, then you probably own the EPA lawsuit, and you can call us if you are a client and we can tell you. And because that one hasn't settled yet. And there's people believing that that one's going to settle for equal to or greater than the state one. And that remains to be seen. It's political year, but I need to do something. Now, finalizing claims and assuring appropriate distribution. This is the last part of her claim that I'm going to go into. So there are other issues that must be addressed in the settlement process. Identifying the representative of minors. We talked about that. That's one of the problems they had. Grandma might have signed up for the lawsuit, but mama coming forward now. Those type of issues are there. The claims administrator is responsible for determining whether the documentation is proper and that there is in fact eligible what is called next of friend. If the documentation is not sufficient, then the person who submitted the claim will receive a notice to that effect. You all, some of our clients, we getting a lot of deficiencies for next of friend. We telling grandma, and I think we mentioned earlier how to resolve that if you're a grandma. If we got the birth certificate of your kid, then we're gonna need the birth of your grandchild, then we're gonna need the birth certificate of your child, because the birth certificate of your child will show you as the parent of their child, and then it shows the parent on the child's birth certificate, so we can establish the grandchild grandperson relationship. That's one way we can do that, and we can keep you on that too. So we try not to make this complex probate issues evolve up out of here, but we need y'all help. Duplicate claims. The claims administrator has identified 3,200 duplicate claims. Mean they the same people. A lot of people signed up with multiple law firms. Right. So what's happening is that's coming to a head. Whoever you with last, the court gonna assume that's who you pick, and they gonna make the lawyers split the money. You ain't gonna be charged fees by all them different law firms. The judge already said she's not having it, and some lawyers are mad, but they just gonna have to get over it because all them lawyers gonna have to split that fee among themselves. It's only gonna be 1/3 taken out, and them lawyers, I don't care how many of them it is, they gonna have to split that money. Y'all ain't gonna have to pay multiple fees to all the attorneys. That's what I was told by our lawyers. They may seek different compensation categories and may contain different supporting information. Some of these duplicate files was somebody filed a property claim with Pitt McGee and then came over to Napoli and filed a personal injury claim. That stuff got to be resolved in the one case, and that's it. When duplicate claims are identified, the claims administrator must determine the category using the documentation data from both claims. This process is somewhat complex and it takes a bit more time than the typical individual review process. Duplicate claims can present a particular issue when the claim involves a minor and there are different legal representatives. So daddy went over to Pitt McGee and filed the kids. Mama went over to Napoli and filed the same kids. That stuff is real and it is happening. The court got to figure out. So the court gonna take the information that daddy provided because he didn't have the birth certificates, but the kids was living with him during that time, so he got some of the school records, but mama got the birth certificates. So the court gonna have to take the information from both groups and figure out the category of claim. Then they got to figure out who gonna be the fiduciary over the kids. Lord have mercy.
You might have answered it before, but if the person that did the filing is deceased.
Yeah, I did, and I'm gonna go to that question. I'm almost done, okay. And then I'm gonna hold that question because I'm gonna answer this young lady's question and then yours. All right. Determining compensation amounts. The settlement is structured so that the dollar value of each claim cannot be determined until all claims are finalized. I know that nobody want to hear this, but I got to tell you what she wrote. Now, this ain't me saying it. Lord Jesus, don't quote me. According to the Special Master Greenspan's report, determining compensation amounts, the settlement is structured so that the dollar value of each claim cannot be determined until all claims are final. Some lawsuits, class action and mass tort, pay along the way. And everybody's like, why can't y'all do that here? One of the things I've been told is because it costs more. It'll be more court costs and more lawyers sucking up the money than you all would get. So when this settlement was made, it was determined that the settlement is structured so that the dollar value of each claim cannot be determined until all claims are finalized. The amount allocated for each claim category is to be divided among the claimants who qualify for that category. So every adult that had 5 parts per billion led to 9 parts per billion or had certain serious illnesses, even if they didn't have no lead, but they doctor said, I'm picking on you again, Ms. Riley. Ms. Riley's blood pressure is such that I believe it was affected by contaminated water. So she ends up in category 23 as well. Now what happens is everybody in category 23, whatever amount of money is going to that category, when they get that final number, they're going to divide it by that amount of people. And that's what the check going to be. They're going to do that for each category. And you got to keep in mind that all of the adult categories is going to be dealing with 12% of the money. So I can tell you for a fact, whatever that number was going to be today, it's going to be more tomorrow because there's going to be less people in those categories when the court get done. Distribution of funds. The special master office, along with the Master guardian ad litem. This is a person representing kids that don't have no representation. Are currently evaluating the process and mechanism for distributing the money. They're gonna give y'all an option on if y'all wanted to come in the mail, if y'all wanted to go direct to your account, but trust funds are gonna be different. They're gonna have to determine who the fiduciary is, because my understanding is you're gonna immediately be able to go access a certain amount of money no matter what for the kids. So my them still gonna be able to jack a little bit of the kids loot. I mean, get a little bit of money initially to be able to do something. So it's probably still gonna be stuff with the kids' money. They gonna get them a little toy. I'm just humor good for the soul, y'all. I gotta have a little bit of that. Lord, this is some heavy stuff. So sometimes I try to make a little lightness. Distribution to minors under Michigan law and the provisions of the settlement. Compensation awards for minors cannot be paid directly to the minor or to the legal representative. Michigan law allows up to 5,000, 5 bands, that's that money, to be paid to the next of friend or whoever the legal. So mom and them can get $5,000 immediately of their kids' money. I don't mean to make light of it. Y'all already know what's gonna happen. And so, but any amounts above that must be managed either by a court-appointed conservator or another mechanism. Some of y'all are savvy enough that when y'all kids get that money, y'all gonna probably hire a different lawyer and say, we don't want y'all to manage our kids. We're gonna form our own trust and manage our kids' money. That's gonna happen. And y'all gotta watch for these predators when these award letters come. MC Law, JG Wentworth and them, they gonna run into Flint and they gonna be buying y'all cases for 70 cents on the dollar. I hope y'all don't go for that. Because if y'all gonna go for that, shoot, me and a couple of us need to go and get together and form a little group and do that. But no, seriously, y'all got to watch out for that, because that's gonna happen next. And y'all got to be y'all. We gonna have to call up all y'all advocates when that happens for y'all to get on them. But many amounts. So in this settlement, the payments to minors will be either to a trust or through a structured settlement. Y'all saw the JG Wentworth commercials. Structured settlement. The court has approved 2 trusts. The court has approved 2 trusts, a settlement preservation trust and a special needs trust. You know, there has to be a special needs trust, because if the kids is homeless and living outside, mom and them should be able to make that argument and say, hey, look, we gonna have to take some of this money and get a house. And the special needs trust is gonna be able to do that. So we know that Flint ain't like most. There's a lot of people living below the poverty level, and there's going to be ways for y'all to move forward. Now, me personally, all of the joking I just made, me personally, this red, every time I step over it, it's just me personally. So what I'm saying is, it's not my risk. I don't believe it's anybody's responsibility personally to tell a parent what they need to do on behalf of their children. You raised them, you've been taking care of them. I even believe, even to the point of you jacking the kids' money off. I don't think it's too much government in our business anyway. Yeah. But that's me personally. Now, stepping back over here, the court ain't gonna let that happen. They're gonna have 2 special trusts, so you can't run off with the kids' money. And cause JoJo talked real good to you, and you don't gave grandmama a couple dollars and say I'll be back in a week, and 2 months later you still gone jacking off the kids' money. So there's mechanisms for that not to happen, because I know people are concerned about that. There are mechanisms. The representative of minor claimants have already submitted payment election forms. So some of you all have gotten payment election forms on what kind of trust you want to go in. And if you haven't, contact your lawyer. Me and Jamie and them could get that from New York so y'all can figure out what kind of form. But I would ask you just hold your post for a few more minutes, because we want more details. We want it to be broke down to the last compound in a readable way that everybody can understand. I've asked the law firm, give me stuff on an 8th grade reading level. Don't put all that legalese in it, because you're just gonna be confusing people. So we're trying to work through this, y'all. Payment options for adults. The special master office and the master guardian ad litem are working on providing different payment mechanisms for claimants, and including digital payment options, ACH, direct deposit, and traditional check. So they'll be almost like government treasury checks they'll be that coded so that even if Pookie, Ray Ray, and Junebug and them get to it, you'll be able to get it back. It's not going to be easy to cash, because you know what y'all know Lord Jesus. So the distribution agent will be responsible for confirming the claimant's information and location so that payments can be sent directly. Hey, look, y'all, the fraud is already starting. It's already companies. Some of y'all been getting a call from the 888-726 number out of California, asking you about your lawsuit, getting personal information. Report that. There's already people going to be trying to get in the mix to get y'all. So just contact your lawyer direct. We have flyers with our number on it, and if you're not our client, then we'll try our best to direct you to who you want to. Now, one of the things I requested is a copy of the master list that the special master have of all of the claimants and who their lawyer is, or if they don't have a lawyer. Because if we had a copy of that list, then what would be helpful is we would be able to at least tell a person who their lawyer is if we don't know. So I'm thinking we might have that soon. We had that at one point. It was real old, but the lawyers that gagged us from just giving it, I don't want to be gagged. Now, timing of fees. The lead lawyers have, now this the question about y'all been paid money. Y'all are due transparency. So I'm going to tell y'all the truth of what this lady is saying about that. The lead lawyers have been paid certain common benefit fees in accordance with the court orders, but have not been paid any fees in connection with the actual claims or pursuit of fee agreements. Ain't nobody been paid that percentage of what their clients are going to get. The settlement process is to set up so that individual claimants do not have to worry about paying any fee directly to any lawyers. So say, for example, you had an expert test, the bone lead test, and that came with a fee. That's going to come out of the money. It's not going to go to you. And all that's being renegotiated, because the judge going to be the final say on what somebody going to get. And that's the truth. Investment. Finally, it should be noted that the settlement funds, soon as they was deposited, they were invested in the T-bills. And as of the date of this report, as of April the 16th, 2024, as of the date of this report, the fund has earned approximately $46 million in interest. $46 million in interest have been generated. Now, I know North Star Law, which was a law firm in partnership with Napoli. I don't know who talked to him, but North Star Law, they done filed a motion that all of that interest got to go to the adults. They feel like the adults ain't getting enough money, and they want all the interest to go to the adults. So I don't want y'all to think that y'all advocacy don't mean something. It do. And y'all got to keep putting y'all foot on the neck as best y'all can about this stuff, because it do mean something. Now, whether that happened or not, I think that should be the discretion of the judge, because otherwise they would just use the existing formula, and 2/3 of it would go to the people and 1/3 of it would go to the lawyers. But 46 million, and it's still generating. Until it's paid out, it's going to generate. That's right. So if the lawsuit was 626 million, the amended lawsuit, we can take, because I ain't good at math, 626 and 46 equals 6. That's $672 million that should be now distributable in this lawsuit, not counting the 8 million that was settled on the other lawsuit, and not counting what might come up with the EPA, although that's going to be a separate suit and separate distribution. It's not going to be in that pot. So the conclusion is the review process is careful and considered to ensure that the settlement is responsibly implemented. That means that every claim must be given careful and accurate consideration so that those who are eligible are not denied compensation because of error or technical difficulties. Sometimes it takes a bit longer to implement the necessary steps to achieve the correct results and ensure that those who are eligible receive compensation, and that those who are not eligible do not receive funds from this settlement. So y'all need to know, if you wasn't in Flint, a lot of these firms was from New York, and you might have lived in Flint Township, you might have lived in Grand Blanc, and they just took your information. And you like, well, what you take my information for if I wasn't qualified? Well, you know, even if you live in Flint Township and some parts of Beecher, it's still gonna say Flint. So a lot of them lawyers didn't know, but y'all know. But what's happening is, so some people ain't going that a lot. I know a lady in Flushing, she had 11 parts per billion lead test, but she never lived in Flint. She ain't working in Flint. And I had to tell her, I love you like a play cousin, but I don't see no path forward for you because you never lived in Flint. And she was like, I mean, hot chili pepper bite mad. And I had to tell her, well, man, what about the people in Flint? Don't you think they should get that money? And then she was like, oh, well, I guess, you know. So this lawsuit, hey, I'll be the first to admit this lawsuit is imperfect, y'all. It is imperfect. I ain't making no excuses for nobody. We could always do better, and we should not give up the fight. But I think it's time to pass this money out. Yeah. All right, so we're gonna take her question. Where the lady at the had the question? She left, and then Art. So come on.
I want to know what is the correct letters and numbers where I can find that report that you have got the reading from.
I don't understand what you mean. What's the correct letter?
Case number.
Oh, the case number and the ECF number. All right, yeah, it's gonna be on the top of this report. I'm gonna want you to take a picture of it. Lindsay, would you set two of them reports on the paper? And y'all can take a picture of it.
Yeah, but I was writing it down. I think I have to get it in mind.
You don't want to do, don't worry. All right, so come on. All right. I understand. I know you like to play good, so I'm gonna you can find it at courtlistener.com. Hold on, say that louder. All right.
Courtlistener.com 16-CV-10444.
All right, so courtlistener.com. Wade B. Snyder. Wade B. Snyder, because see, you can go on court and get this report. Wade B. Snyder, courtlistener.com 16-CV-1044. 444. Courtlistener.com 16-CV-1044. Thank you. Thank you all for that. And the documents are there for y'all. All this document is there because this is something you all would then know for yourself what's going on. And it was kind of mentioned that June, I know everybody thought with M Live said June, all the money gonna be distributed. You see, that's just gonna end the first round. Now, where's that? We're gonna go in order. Where's that second lady? She ain't there? No. Well, go ahead. Go ahead, Art, and then we'll come back up here. And then we go there.
Reggie, love him to death. Love him to death. And I'm not trying to prove him wrong or anything like that. You know, I just want him, you know, because he said he didn't know if it was in there or not. And I just want people to know, because once you get to that reconsideration stage, you're going to have to need documents because you're going to have to make a choice. And it's under ECF number 1394-2, Exhibit A in the revised amendment master settlement.
Okay. You get that ECF number one more time.
ECF number 1394-2, Exhibit A, revised amendment master settlement agreement. And it's on page 46, section 13.7, where she says any claimant, and it's appeals to special master, any claimant or next friend taking an appeal will be charged a fee of $175 by the claims administrator that must be paid before the appeal may proceed. And the only reason why I'm saying that is that, like Reggie said, they're gonna tell you what it is that you need. So you might as well start working on it as soon as you get that first denial, because you're gonna have to make a hard decision if you're not represented by a lawyer.
She asked now let me say this about that. I believe that the language on this report on page 10 and on page 11 speaks of initial reconsideration, that's not gonna cost. When it says each claimant is permitted to ask for reconsideration of the claim if the claimant disagrees with the notice and is permitted to provide new information that can cure the deficiency, the claims administrator will then review the claim again and provide a reconsideration notice to tell the claimant the outcome of that review. And then it says for the third one, or the non-informal one, if the claimant disagrees with reconsideration notice, the claimant can appeal to the special master. And as of March the 28th, it was like 149 people did that third appeal. And I'm believing, based on what Art just read, but I'm gonna get clarification, that it's that appeal that's gonna cost that money, but the initial one is not, that the lawyers get to do. Correct. But I believe it's that one that Art talking about, that 149 people elected to take. But I think most people in that first reconsideration should be able to get it done. But that's, let's make sure we clear on that one though. Right? Okay, it's that third.
Hey, real quick, Greg.
Come on with it.
Will, the statute of limitation for Viola lawsuits.
On the
statute of limitation on it?
On the Viola lawsuit?
Yeah.
I don't know. But I'll find out. All right. You want to know if there's statute of limitations on that Viola lawsuit? Because I think what you're saying is if a person don't like that 1,500 that's only gonna go to the kids, that they can opt out and redo something different. Is that what we're going with that? Well, let's find out. I don't have no problem with questions. I think that should be answered.
Yeah.
So I'm looking forward to giving Art that answer. And y'all know he gonna tell y'all, give me that answer. Okay. So we'll be able to figure it out. Yes, ma'am. I think you was that lady.
Okay, the booklet they sent out to us here not too long ago, we filled it out, turned it back in. And I know my claim is okay, but I wanted to know about this book because we got the book, we filled it out, and we sent it back in.
You talking about that book in January?
Yeah.
Now, let me say this about that. Most of y'all who had attorneys never even had to fill it out. If you would have looked on page 1, the last paragraph, it said, if you had an attorney, just give your attorney a call. That was primarily for people who didn't have an attorney on that $8 million settlement that was being made. Our retainer agreements annexed that already in there. So you didn't actually have to fill that out. But the court had a duty to send that notice out to everybody. That's almost the same confusion that when they hired Archer the first time and they sent them white registration packets out to everybody, even though you already did that with your attorney. So there's some inherent confusion that's built in some of that. And the best thing you can do is contact your lawyer. Now I'm gonna try and speed through these questions because I know when they gonna kick us out the library? Are we past that time? Are we past that time? Can one of y'all go see how much more time we got? Oh, Claudia, you were charging. How much time we got?
It had up until 4 o'clock.
All right, so y'all, we about to get kicked out.
The lady behind is going to explain about the deceased, the benefit parents for deceased.
Okay, now again, on deceased claims, under Michigan law, you're supposed to go through the probate process. If somebody died, you're supposed to go down. This is supposed to be normal. You're supposed to go down to the 5th floor, room 503, and fill out to become personal representative over their estates. When somebody died, power of attorney died. Power of attorney don't live past the death. That's right. You got to become personal representative. The good news is, if you're a Napoli client, I got to use that caveat, you can come and we will fill out the paperwork for you for free. You ain't gonna have to hire a lawyer. And the reason why these law firms are not representing you on deceased claims, because they expand more than the lawsuit. If I die, God forbid, today, my wife might have a house or a couple cars and some change that they can get outside of the lawsuit, so it has to be probated, especially if you did not leave a will. And most of us don't have wills, I done found out, or none of that. So you can get help. Now, the court assigned a special probate judge. This probate judge, we looking at a document, and I'll try and get that document to some of these advocates who will put it out there, where you ain't even got to go down to the probate court and spend no money if it's a certain amount or less that and it's probably only going to apply to a property claim, because y'all just do the math. Contrary to popular belief, based on the amount of claims we just named and the amount of claims they're gonna get rid of, some kids gonna have enough money to go to college. I'm telling y'all, it's not gonna be no $500 lawsuit. And even the most smallest claim, that property claim, we know from the grid that's not paying 1,000. That's not correct. Maybe if you have to split it up among a bunch of people, but if George give me proof that he lived on Court Street in 2014, 15, or 16 and had the lease or the rent to own, and it was strictly him, he gonna get $5,000 according to what I read. And I'm gonna make sure I get that out to the appropriate advocates so they can see it. I had this conversation with lawyers on the property claim recently, and everybody been going around saying it's just 1,000. It could be that split, but according to what I've been told, it could be $5,000, but I will get full clarification on that. And that's the only one we have a number on. Yes, ma'am.
Okay. You said that we could also get a number and so we can pull it up and make sure your claim is correct, because when I fill out all of mine, I had to sign paper.
Who's your lawyer?
You guys.
Okay, you can just come see them. They can tell you right now. They can pull your case up right now.
Okay.
Hold on. We got to get this young lady. Come on.
I just want to know, I want to put my dog's money in a trust fund.
Your dog's money?
My daughter.
Oh. Did you come to the dog?
I'm sorry.
All right.
No, my child.
Yes, ma'am.
In a trust fund, can I put it in credit union because I had to do whatever they decide?
No, it's not going to come in no credit union. Yeah, that's
Okay,
out. The court has created 2 trust funds.
Okay.
There are 2 trust funds. One is the court has approved 2 trusts, a settlement preservation trust and a special needs trust. So there's 2 trusts that the court have already pulled. And on that website that Art and the young lady had, y'all should have an ECF number 2171 that actually have that detailed information. It's a special order granted motion approving the settlement preservation minors pool trust agreement, joiner agreement, investor policy statement, and trust fund fee schedule. So there is that information is available online, but I'm gonna try and just pull it up. You're the one that didn't have a lawyer, right?
No, I have Arthur. And they
don't tell you nothing?
The only thing they sent me was a notice back in December of last year that they're still goes in the paperwork and they'll send me a.
And let me just say this, if you a Natalie client and they kicked us out of here, just come write your name and phone number down here and we'll call you. We'll be even working tomorrow. We'll call you and we'll tell you what the status of your claim is. Come on, Art.
Somebody on here want to know, do they charge parents for the trust fund?
There is that's a good question, Art, and there is a trustee fee schedule on this order, so I'm assuming that they're gonna charge to maintain this trust over time. I don't think it's gonna be free. I think it's gonna be like any other trust fund, the fees that come with it. But the good news is normally trusts generate interest. So normally the fees, from my understanding of trust, are relegated to be paid out of the interest that is generated versus the principal on the money. So that's a good question. And I think what we ought to do is look at the order granting the motion to approve the settlement preservation and see what that fee schedule is. It's on there. So we're gonna look. But the short answer is yes. Yes.
Where's that fee order at?
Yeah, let's look up all this stuff. Come on, young man. Come on, young man. Come on, young man.
I got a question.
Hey, y'all, we still got some questions.
I got a question. The gentleman in New York, I called his office and I asked him. Now, from what I understand, it's around $3,500 million that will be divided among 70,000 people. Help me here.
35.
What is the amount that they will be getting here?
Okay, so according to what we looked at today in the interest we calculated, $672 million is in the book.
Okay, for 70,000 people, right?
No, sir.
How many?
According to what I just read in the special master's report, there was 46,000 claimants and 3,172 of those are duplicates. So it's gonna be probably less than right at or over 30 30,000 people.
Okay, 30,000 people are gonna divide that. 70 Boy Scouts are gonna get $700 million. Now, what I wanna know, and I know you're not at the top of the totem pole on this, so it's not you that's pressing upstairs. But I wanna know, how do I find out who has, how much legal malpractice insurance do they have? How do I find that out?
I don't know how you find out how much legal malpractice they have, but one of the things I do want to share with you on the on that Boy Scout case, there was 98% participation. Less than a third of the people in Flint signed up for this suit. There's no way that if 2/3 of the people in Flint would have signed up for the suit, you'd have over $1 billion settlement. So part of the low amount here is the actual participation of the people at the time of the settlement. At the time of the settlement, you had less than 30,000 people had signed up. And when the judge announced 646 million, she left the suit open for 6 months. And you had almost an additional 20-something thousand people sign up for the case, but the money amount didn't increase. The money amount didn't increase because at the time of settlement, they went off of the settlement was based in part. Same thing with the Nassar suit. Now, that's no fault of the people. That's no fault of the people. I don't want to come off like that, but you need to understand that is a factor. When you get 90+% participation in a lawsuit, them numbers gonna be different than when you get less than a third participation in the lawsuit at the time of the settlement. And I just want those of you all who are reasonable and logical to calculate that factor in there. Now, the question could be asked, why? You know, why? Now, one thing you can't do.
So your people don't have to run.
Okay. Oh, okay. Well, let me slow down a little bit. I don't know if they're gonna stay that long. I got to pay. And yeah, we gonna they got obligations. I told before, but thank you for that. So if they have to leave, we probably not gonna stay to 5:45, but we'll stay a few more seconds because Valencia and them gonna jump on me. And I can't have that. So to your question, I can't answer that. I don't know how much malpractice insurance these lawyers got. And I don't know how you find that out. How much is your personal insurance policy? Who business is that? I don't know. So I'm not going to pretend to answer a question I can't answer. I have no idea. But be careful because all lawsuits have to be valid. And I think that's going to be a factor that'll be hard to overcome. You can't compare a suit that had 90% participation at the time of settlement versus a suit that didn't even have 1/3 participation at the time of settlement. That's one of the problems we got to deal with. It's just real. It ain't a playoff. It's just real. Come on, Miss Riley.
I'd like to say, I think you've done a phenomenal job here today. A phenomenal job.
Yeah. No, listen, I know this is difficult. And advocates such as this gentleman, that's a good question that he actually asked. Because what I hear in his question, let me tell you what I just heard in your question. We in Flint, we poor, we depressed, we heavily minority, and sometimes we just don't get the same type of attention that other communities get in a lawsuit. I'm not devaluing what I heard you say. And if there's any type of road to malpractice by any of the attorneys, I'm not getting in the way of that. I think people should speak up on that because there may be some underlying questions. And I think your voice, which has always been loud and ringing in this community, should be part of the voices that and let's look at what we can do. Can y'all that have the voices, I think it's reasonable that y'all join North Star Law and making sure that 46 million go on to the people. Y'all can write letters to the special master. Y'all can do different things to assure that 46 million maybe go to the adults. Since 79% of the money going to the kids, maybe that money needs to be added to the pots for the adults. I'll let y'all decide that. But don't ever think that you don't have a voice or you don't have influence. One of the things that I appreciate about the advocates, especially those that are in the room that I know advocate all the time, is y'all use y'all voice. And even though y'all are frustrated because a lot of times you don't think people are supporting it, people do hear what you say. Trust me when I say they do be hearing y'all. And sometimes they make decisions just based on y'all voice. So don't never distinguish your voice because your voice is important. And what you just said, you know, that's leverage. Come on, Art. Yes, sir.
Hey, so I heard you mention something earlier.
Come on.
Cancer study. So let me ask this question. Right?
Come on, man.
So if somebody sign up for cancer, I mean, for this law, would they waive their right to sue if their parents, somebody had, like my aunt signed up for this right here. And say they find out that TCHM, just like Campbell June, caused cancer.
Mm-hmm.
Would they be able to get on another lawsuit for cancer against the state and everybody?
Well, let me answer this that way. First, I'm not an attorney. I do not give legal advice. And though, having said that, there's something in law called cause of action. So was TTHM a cause of action in this lawsuit? No. And so if it wasn't, then plus on the waivers that people sign with settlement claim form, you agreed not to sue the same parties for the exact same thing. So if this is different, then it's not the exact same thing, and I don't think you gave up your right to, or waived your right to sue on behalf of your aunt, who and my condolences to you, man, who died because of cancer. You all gonna find out. If we didn't find out nothing else, one of the things we should do is don't faint or get worried, because we should take the data from this lawsuit. The data from this lawsuit should be valuable for us to advocate further. Y'all know doggone well that this lawsuit was a lead contaminated lawsuit. It wasn't fighting all of the things that you just named. So let's take that same data and that data track, remix it, like y'all used to do in the kitchen. Remix it, and let's come up with some more advocacy. Because Flint, one of the things I personally learned from this lawsuit, y'all, is Flint is heavily contaminated. Oh my goodness. Even before this lawsuit, I've had the privilege of going on site to home inspections by several different environmental companies. They inspecting the Flint house, so then we hire an inspector to go behind their inspection to see if they cheating. And we found homes that got all kind of contaminants in the window shields, in the paint, in the soil. And the defendants would argue that these contaminants was there before the lawsuit started. But to Art's point, some of those contaminants are things that's not subject to the lawsuit. They found other, and they might say, we found other ancillary or inert contaminants, but they was only looking for this, but they done found this. And it's that other stuff that they found that might lead. I know y'all gonna hear some people say, man, I'll be glad when this over and stop suing. For our community, this should never be over. We should always find a way to fight against what's happened to us. Dow Chemical, General Motors, y'all see the runoffs, they run right from the water, from the plant into the water. Hey, we ain't never should have been drinking out no doggone Flint River. And the problems that evolve from it is much more than this lead contamination lawsuit. So, brother, keep advocating. I know you sometimes feel like everybody treats you like the villain, and you have a very strong personality. I like joking with Art, but it's people like him and other advocates in this room, Dr. Riley. Y'all got to keep this, brother. Y'all have to keep doing what y'all doing, because y'all don't really know the impact it has. So let's give y'all a hand for the stuff that y'all, George, all y'all that fight on the level that y'all fight. Don't get tired, brother. And I might even give you $2, but don't get tired. I donate. Start your nonprofit. I donate at least $2 to it. So don't y'all get tired. Any other questions? Yes, ma'am.
A letter, if you have not, if you didn't receive the letter saying that you were approved.
Yeah.
So does
That notice letter. That don't mean you've been denied. It just might mean the court hadn't got to you yet. Remember, she said she's gonna be first round review all the way up to June. And so now, if we contacting you about deficiencies, that mean they have done the review, but we got to overcome these deficiencies. And once we overcome the deficiencies, then they're gonna re-review it and send you out the notice letter. So are you a Napoli client? All right. Have we notified you about any deficiencies? Make sure before you leave, you come and give Jamie them your name and your cell phone number, and anybody we don't address right now, we gonna call you and make sure you updated on where you at. Yes, come on, Ms. Riley.
One last question.
You can take a few more.
Okay, one last question. Why is it that Napoli continues to send repeated emails even after you have contacted them and talked to them personally? And now I'm still getting texts, and so I send them the same information that I gave when I was in your office the other day.
But it's unresolved because, for example, and I'm not gonna go into details about your matter, but what you gave us didn't resolve it. It was just information. I think I told you what we need, and it's something you're supposed to come pick up so you can take it to those people and get it signed.
Well, you did. You gave me the paper to take to them.
The affidavit?
Yeah, that one of the persons was out of town, and then one of the persons had a death in their family. And
Until it's resolved, you're gonna keep getting emails.
But I did give them their name and their phone number.
They're not gonna, that doesn't stop it. It's the document I gave you that we're gonna need to resolve it. So in short, until it's resolved, we got robots, we got people, we gonna print, paint, stamp, stain, cut and carve, do smoke signals, throw rocks. Until that thing is resolved, we gonna put, Now what I'll do in your particular case is, Jamie, let's get Ms. Riley's number so we can put client informer on her deficiency part, so the robot will stop contacting. Okay. Yeah. We can do something to stop you from getting contacted. All right. Art, and we're going back to government.
Real quick, and I'm done.
No, take it up.
So a lot of people that I talk to, and being a veteran and dealing with the VA, one of the main things that we have to have in our claims is more likely than not.
There you go.
So you know where I'm going, right?
I mean, come on with it though.
A lot of doctors around here don't want to say that the people's illness was caused by the water.
Right.
So what's the wording that a lot of people, because you and I had this discussion before, come on, you said that they don't have to use more likely than not, but they can use another term.
Well, it was almost that. So at one point, we were giving out what is called link letters. Our clients was coming into our office because their medical records had high blood pressure, or it had anemia, or it had lung pneumonia, or it had a stroke during this period of time, or it had skin rashes, or it had hair loss, or it had gastrointestinal issues, or it had Legionnaires, or it had miscarriage. These are 9 specific injuries that are known to be either caused or exacerbated by contaminated water. And even if that's in your doctor's report, if your doctor did not say that that was caused by contaminated water, then the reviewers, when they see that the first time, they're going to say no qualified person supported this injury. So at one point, we were giving out what is called link letters, Art. And in that link letter, you was taking it to your doctor, and it said that my high blood pressure, it actually had the language, is reasonably concluded that it could have been caused more likely than not from contaminated water. So it gave the doctor an out, where the doctor didn't have to say 100%, but it had that veteran language that Art was talking about. But the problem is somebody from another law firm, because we was doing that with a lot of our clients, ran to the judge and told us, they doing what we ain't had the ability to do. So what happened was the judge stopped it for reconsideration, because they said Art might have the ability to go push up on his doctor, and he do, and say, hey man, you better put in here this language. Would you try to stop me from getting money? Whereas some people don't have the wherewithal to do that. But to me, that's not a problem. It's still your doctor writing the information. If your doctor write that information, so I would encourage anybody. Okay, I got to stand right here when I say that. This ain't love, this rich. I would encourage anybody who have not, if you know who your doctor was through 14, 15, and 16, and you didn't have high lead as an adult, but you had any of those other conditions, go make your doctor write that it's reasonable or more likely than not, that person's high blood pressure could have been exacerbated, especially if you had high blood pressure before the water crisis started, but it could have been exacerbated by contaminated water. I didn't sign up for the suit because I was working for the group, but I was guinea pig for the bone lead test because you never going to let nobody say that I didn't do something that I'm asking you to do. You would never get that. I took it 15 times. But my high blood pressure during that time was almost uncontrolled. I'm like, Doc, I don't have no other issues in my life but this high blood pressure. Why can't you bring it under control? So I believe I'm one of those persons who was affected, but my doctor didn't say that. But I could have I could have convinced my doctor to write that if I was in the lawsuit. No doubt about it. Guarantee you he'd have wrote, because I wasn't going to leave until he done it. This gentleman and then you.
One of the things was there was a letter sent from Lansing on the doc and saying, don't deal with this.
Really? You got a copy of that letter?
What's the name with the long hair?
Please give me a copy of that letter. I guarantee you I can get that to some lawyers and we can challenge that. You know, you can't be talking us to death now. If you got that letter, you get it to us, and I guarantee you I'll get it to a lawyer.
He had a copy of the letter. Now, number 2 on there, you read off that they have put somebody over handling the money. Now, the experience that I'm talking from is when my son was in a car accident. Okay. And he had a lump of money. We got him a lump of money. And every 6 months or a year, we were supposed to tell the court where the money was at or what it was doing. The lawyer was charging us $150 every time. And I called him, and there's kids in the room, and I said, such and such attorney, you're open kids now. He said, no. I said, no, you open kids now. Okay. Okay, and we stopped him from doing it, and my wife did it. So
Now, you know, law is not finite. If my kids get some money, you know, it would take heaven and hell if I didn't like the way them trust was managing it, not for me to hire my own trust attorney and get my kids' money transferred. Well, I'm just simply, okay, well, I'm just telling you the path that's been, you can look at this. There is a trustee fee schedule that's attached to this. So part of what I'm going to do, and my team is going to remind me, is to try and get a copy of this document that has the on page 14 of the agreement. Let's find out what that fee schedule is. And I don't think y'all gonna be able to.
Mind you, that was 15 years ago.
So you know it's more now. Come on, young lady.
So why do we have to put it in the trust? Right, because why, we already losing money, right? Because the lawyers, they really got paid. Let's not ignore the fact. They got a fact. So why?
But that's not a fact.
How?
According to this report, that's not a fact.
Okay, well, we'll see it.
We absolutely will.
So, 'cause that's gonna be a black and white too. I'm trying to figure out.
Yeah, you signed a retainer agreement for your lawyer to get a third of the money. That's nonprofit.
That's show right. But I'm saying, here's the thing, we being pushed into another lawyer with the trust. So then we paying these lawyers to get the money, and then we paying these lawyers to handle the money.
The girls in the office.
Yeah, first of all, let me address.
I'm saying, but there's 2 different types of lawyers.
Let me be real clear about what you're saying, because I work with a law firm.
Lawyers are good at words, and it's the wording that counts. So I understand, because I done paid a lot of lawyers out, and I dealt with a lot of lawyers.
What you hire a lawyer for? Because you can do it yourself, right? I don't mean in that case.
But
I mean in this case.
Because we was kind of bamboozling and fooled into one thing for one. We haven't seen no results. It's been 10 years.
Well, man,
10 whole years. Not 10 seconds, not 10 minutes, 10 whole years. So I'm just here. I'm gonna put it on the table. I ain't gonna be nice because I suffered through it. And I'm still going through it. Ain't nothing nice about this. And I'm tired of hearing the runarounds and the circles and the crosswords.
First of all,
I asked you one question. I said, why are we paying 2 different fees for two different sets of lawyers. A trust lawyer and the lawyer to set up the criminal suit for these people, civil suit, is two different lawyers.
If you just take a minute and breathe to your question. Just take a second and breathe, because if you come off hostile and attacking, I'm trying not to match your energy and come back with the same energy, because some of what you're saying is false. So let me just answer your question. First of all, the fee schedule, I think you should look at the order and see exactly what it is. Your client, directly answer the question, the child is our client and the adult is our client. If you go to probate court right now and a child is involved, if I die and I don't have a will and I have a child and somebody try and get over the child's money, the court will appoint a guardian ad litem to make sure that my child's interest is represented. The child is a separate client. They're not going to give the money to the parent. They're going to have a representative over the child. The child is a separate client from the parent. They're individually represented. So that representation is going to continue with their money, because some parents, when they get the child's money, they're going to spend it. They're not going to preserve the child's right to spend that money. That's the child's, the way that they want it spent, because they're a child. Now, I agree with you that as a parent, the government shouldn't tell you what to do with your kids' money. Having said that, they do. The government saying this child is not, we don't want the money earmarked for this child completely spent by the parents. So it's going to go into what is called a trust. Now, having said that, you will have the right to fight to transfer it to a different trust other than the ones the court picked. But it's going into a trust because the child is its own client of ours, separate from you as the parent. That's why it's going into a trust.
I understood that, but I'm saying that's another fee. If y'all gave us a lawyer, we paid that trust. And then I got to get another lawyer to pay them to take it out that trust. So that money is coming out of me yet again from this settlement. So now I'm dealing with 3, 4, 5, 6, 7, 8 lawyers because it's put into a trust. It don't, but I'm just saying, you just can't, I mean, it's 3. The lawyer that started the suit, then the trust lawyer that's taking over for the kid, and then if I want to transfer it, that's another lawyer. 1, 2, 3 law firms. So we get paid for every sheet of paper they sign, for every phone call they make, for every text message we send. Some of them charge $150 for a 2-second call. I'm just saying, this is what I'm asking. Why? Why wouldn't we send out a letter and say, hey, your kid have to have a trust lawyer? I might have my own trust lawyer with my family. And then, but why should I have to when it should have been brought to me?
Because the client is represented individually. And the client has to
understand that.
So what do you take your kids?
I understand that.
I don't know what you want me to do.
I said, why? No. I want to understand why. You're not answering my question.
I 100%.
I know we're separate. But I'm saying, before y'all decided on your own.
I answered your question. Did you hear the answer to what I said?
Now, if you listen to my question, I said, why did y'all send out a letter and say, hey, if you have a trust lawyer or an estate with your family, you are more than welcome to send this money to your family trust.
That was an option for us to do. We're under.
But y'all here to represent us.
And we also, right, that's why your kids have a trust lawyer, so that your kids' money ain't jacked off. Okay. That's exactly why they have a trust lawyer. Well, then why won't you make that argument? Why are we going to assume that you have one?
Why I can't go to my lawyer and be like, look, here, my son got a trust lawyer, I need you to handle it. Because I don't want to go nowhere.
Bring that to us then. If you are a client, bring us that information instead of arguing about it. Did you do that? You should do that. I agree with you. If you have a trust attorney, then take that to your lawyer and allow your trust attorney to take it over. You should do that.
This is like bodily injury from a child under a car accident, right?
Or you the one that got hit and say, but if you got one, you the one you got.
Because that's not an option at this point. That's an option that you would create. That's not an option that the court is offering. So we read this.
Can the lawyers go to Judge Levy and ask Judge Levy
Because that's a great question.
Don't leave.
I mean, if they already. Why would you do anything other than, why would you assume that a person, if people don't even have the money this is a contingent lawsuit, first of all. Right. Meaning that the lawyers get paid if the client get paid. So you're asking a lawyer to create another legal issue and not get paid for it. Law firms are not nonprofit organizations, are they? They're not going to create another legal issue with the aim of not getting paid for it. They're going to get paid for their services. And so what the court did, just like, see, this is the same thing. If you go individually, forget this mass lawsuit. If you individually go down to probate court right now, and there's a child involved in that case, the court is going to appoint that child a lawyer. The court going to do it. It's called guardian ad litem. The court is always going to appoint somebody to represent the interests of the child. This lawsuit is no different than that. They created two trusts for the kids. None of that stops you as an individual or parent from fighting to have your own trust. There's no rule or law doing that. But why am I going to fight to create you another separate trust when there's already one created? It's too creative. If you don't like it, then you go, or if you already have a trust attorney. We have clients that have trust attorneys. Trust me when I tell you, I'm sure that what they're going to do for their kids or their grandkids at the appropriate time is get it switched over to their trust because they already had those attorneys. So that's not even an argument. That's not even an issue. That's a choice. You have the Sixth Amendment right to counsel of your choice. Nobody can take that right to you. Sometimes I think we just be arguing without asking the questions. Like that young lady asked the question, why? And the question was because each person is represented individually. And just like a probate court is going to put a guardian ad litem over the interest of a child, it could be your child. If you go to court, the court will issue, if you go to probate court, they're going to put a lawyer specifically for what's the best interest of the child. And y'all know this. So the same thing happened in this suit. There's a fee schedule. The sister is right. I'm not saying she's wrong. They are going to charge. She's 100% right. I'm not in denial about that. That's not nothing I'm going to try and defend. But what I'm saying is, just like that money is going to be accruing interest. And my understanding of trust, structured trust, is they normally get their fees out of the accrued interest if possible. But if not, and you don't like it, this is America. You can go get you another one. And guess what? When you go get another lawyer, they're not going to do it for free. They're going to charge you for it. They're not nonprofit organizations. So I'm not even understanding why we arguing that lawyers are going to charge for their services.
My question was, why so many lawyers have to pay? That was my question. See, wording is everything. My question was, why do I have to pay another trust lawyer to take it from another trust lawyer? And you do because
no, listen to me.
Okay.
Listen to me. My son was in a car accident.
Okay.
We got him $80,000 out of it. I sued. He was riding in the car with his brother.
Okay.
I sued his daddy's which is my stepson. I sued his daddy's car insurance.
Okay.
I sued my mother-in-law's car insurance that lived with us, and I sued my car insurance. We took the money and we moved it. It was legal to do. We took the money and we put some of it in the bank, and we had a broker in Detroit that we told him where we wanted him to put some of the money at. He did that. And the judge wanted to know every 6 months or every year. I can't remember. We had a lawyer handle it. Let me finish. And then we took it from the lawyer because he was charging, honey, what was it? Every 6 months or every year that you had to go back to tell the judge where the money was, with the queries of money.
Once a year.
Once a year, and tell him where the money was. Okay, then we took it away from him because he was charging $150 a year, and she did it for free. And the judge wanted to know where the money was. He wanted a $1,600 computer one time. She wrote the judge a letter. The judge says, okay. He went down and my wife went and drew the money. You don't need a law. What they're doing of trying to handle it to these other folks in New York, because understand something. I was in an accident in December the 22nd, 1982. I'm still filing claims with my insurance company. Huh? Where they say the trustee board is at? Okay. They're gonna put that to their buddies. So you understand what I'm saying?
That was the answer.
Yeah. Now, I've been down this road. I ain't doing what somebody told me.
So I can take our trust lawyer and.
You don't need him.
No, I'm saying the one we have for our family, and then they can take over the trust for my son and put it in his trust account already. So if he got a trust already, can that be transferred to his trust? Is my question.
That's gonna be a question for the court.
You know the lawyer?
That's gonna be a question for the court.
For the court, that's
I'm
right.
not here to give nobody no legal advice.
You've been giving.
No, I have not. I've been regurgitating the report, ma'am. You just came preconditioned to whatever you was preconditioned to. And I think I announced in there that I'm not an attorney and I do not give legal advice. I manage a law.
But everything you did been based on what she said.
What green one?
No words.
No, everything I've been doing is reading that report. I made that very clear in the beginning.
It's her word, then you should need to be here doing it.
I 100% could be here doing it, just like you could stand up here and do it. Who are you to tell me what I can do and not do, ma'am? You are really out of pocket to tell me what I can do and what I cannot do. You can stand up here and read this report. Who are you to tell me? No, I'm just simply saying people need to get a grip. You don't have, hold on. You don't have, yeah, ma'am, you're very offensive because you sitting there telling us what we can do. You're being very offensive. You're saying, telling me what I can do. Yeah, ma'am.
Excuse me.
It's people, but
I'm Bishop Jefferson, and Democracy Defense is who organized this. And we did it for informational purpose. People were asking where it was. Reggie volunteered. We're not paying him, but he volunteered to give us information that was passed down. When was it? This year?
April the 4th.
April 4th.
I'm sorry, April the 16th, 2024.
April the 16th, 2020. He's reading a report that, like he said, when I was up here, that you can get a copy of it, or you can get the title of what it is, the number, because everything has a number to it, assigned to it in the courts. And so you can get for yourself and read it and interpret it. But he's just reading what was, not to be argumentative or not to give advice. And I want to say that we appreciate him caring enough because he the first one that came out and said anything about what's going on or what they're doing or where they're at. And people ask me every day, Bishop, where our money? When we gonna get our money? And the only thing I can tell them, I don't know. And I was able to tell them that we had organized this day. And downstairs we had resources that many times people don't know what they have in this community. And so therefore we had a resource fair downstairs. You go downstairs and learn about the resources that are available to you, that are due to you. And then you could come up here and get educated about where the settlement is. It's in black and white. Nothing that he made up. You can get copies of your own. But we dare not. We dare not. This is not a shouting match or arguing match. This is just here for informational purpose only. And like he said, I can't answer all the questions because he don't know the answer. And there's been times that when he got off the scripted paper and said, this is me talking. This is what I feel.
And let me say this, young lady. I know you frustrated because I'm frustrated too. And
Argumentative, but I was just asking what I've been wanting to know since it's the opportunity for me to know.
And let me say
And
this.
that's why I was asking because we haven't had these opportunities. But it was argumentative.
It's very important. If you like steak, and I know you like steak, and I give you steak on a plate with some baked potatoes, you might eat it. But I don't care how much you like steak. If I give you steak on top of a garbage can lid, you're not going to eat it. So all I'm simply saying is I'm not your enemy, and you shouldn't attack a person in your questioning as if they done something to you personally, because they have not.
Your question in and of itself was nothing wrong with it, but the way you were delivering it and how you were delivering it, you started being in this, and it's like, okay, now we get into you to tell me what I should or should not do. You might not like what I'm saying, but just like I can't tell you. Yes, ma'am.
Everything you say.
Yes, ma'am.
And you might like my delivery. I apologize if it was bold or wrong. I'm strong-winded. I'm strong-breathed about everything I do. But it's I'm apologizing if anybody took it wrong to be offensive. I was not, but I was trying to get to the questions I was wanting to ask, because this is suffering. I'm changing my not my filters. I'm changing my faucet heads and Delta every about 6 months because the water is corroding. So I'm not getting that value. So I'm not. My tub is black. Every other I'm paying these people, so I just want to know. Then with the trust thing, it wasn't none bad, but it was just that that's another fee that I'm already might not get nothing, but on top of that, here's another fee that's missing.
So he was just trying to say he's the delivery man, and we do feel your frustration.
No, I was agreeing with it. That
Right, he did, and I understand.
And I wanted to understand why wasn't being. I'm telling him to ask the lawyer, is there a way to eliminate that?
The library closes at 5, and it's
10 minutes to 5.
10 minutes to 5. Reggie, we appreciate you. And
thank the Democracy Defense League and the Water Warriors. Let's get in the hands of being able to do that.
So we appreciate when we get more information, we will find ways to distribute it to the community. Thank everybody for coming, and I pray that your concerns were addressed. And if not, what he did tell you to do, get in touch with your own attorney. Get in touch with your attorney, because they should be the ones that are educated. So please, ma'am, please, sir. God bless you. Have a wonderful day. Thank you.
Bishop, when you talk to Claire, tell me thank you
I'm just putting all these all the stuff that everybody said up, and then I'm gonna shut out. It was a few. So we still live, and I want everybody to be able to get to see them. Oh, you good? You good?
Yeah, I was gonna ask you questions, but I think
You should have asked it.
Nah, if you weighed 190 pounds, you got ass, and they give you, doctor give you a hey, you go 190 pounds, 160 pounds in 4 months. So. That's too much money.
I hear you.
Then you stop taking this inheritance, you got to right, child, right. Get it soon. Wait.
I'm still live. I'm putting it on there live so everybody can see what the comments were over every platform. So all the platforms and all the comments from each platform, I'm putting them up. Democracy League. Oh, that's what's up, man. We all got to do more. Yeah, well, everybody hear you. So you just said it. You said it live, so they hear you. Yeah.
Then when you want to you pay y'all kind of 7%.
Right, let's say some young spun around. Hey man, that's why I try to do whatever they ask me to do that I can, and bring as many people from the community to it. Okay.
You say something?
I'm talking back.
So we still live. Tell them we still live, and nobody end up saying nothing crazy. Okay. I'm got a few more.
They got good nothing for last week. What? Well, against this. There's another government, what about, Al?
All right, everybody. We are about to be out of here. That's Out of Mud Media, Georgia Grundy II, your favorite veteran, James Mayfield, and all our